So I was intrigued by your call for centralization of kind of governmental cyber agencies. You've made your fame as a banking lawyer, and bank regulation is famously decentralized. Could you talk about that for a minute? Does that work? Do we need more centralization of the regulation of banks and securities markets?
I think it's a great question and a great analogy. And I would say that the current situation in the financial institution space with 5 agencies with some degree of regulation argues very much for my point for centralization of cyber. I mean, for those of us in the room who have tried to get a question answered under the Volcker rule, where you have to get the concurrence of all 5 of those agencies on anything, you can understand the problem.
So turning to, I was intrigued by what you said about the difficulties in planning for something like a Puerto Rico or even a Greece and the knock-on effects from that. You said that too big to fail has been fixed, or at least has been reduced. But I think that one thing that people want in their financial regulation is some way to kind of cure the need for ad hoc solutions to crises that come up. So that the concern is not so much that an individual bank is too big to fail, but that these knock-on effects where one event can destabilize the entire economy keep happening. Is it realistic to think that we can fix that in advance, or is there always going to be some sort of ad hoc kind of solution to every problem that comes up?
I think it's, to be realistic, it's likely that some sort of ad hoc resolution will be necessary because the problem will be unexpected. I mean, if we could foresee the problem, we'd fix it in advance. But I do think one of the outstanding features of the Dodd-Frank Act is the resolution regime which is there, which provides the best opportunity to take down a large institution without these enormous knock-on effects. And that, plus the resolution planning with all its pain and its expense, I think between the two provide us with not certainty, but a substantial reduction of the risk.
And what about capital requirements? You see people claim that capital requirements are sort of the cure-all for this sort of risk, when they can just stabilize the financial industry from any crisis.
Part of the problem is the bad situations often result in overreaction. So no question about it that before 2008, we had let major financial institutions, some of them, reduce their capital levels to totally unacceptable levels. The issue now is not that we should have much higher levels than were permissible pre-2008, but at some point they do start to choke off credit formation. I mean, let's go to the absolute extreme. If you had 100% capital, there's going to be very little credit given by banks. And there's one other statistic which I find instructive, and that is the same decade which saw the highest capital ratios in the banking industry also saw the highest rate of bank failures, and that was the 1840s. And the answer, if the economic historians are to be believed, is that with these very high capital requirements, banks simply had to take more risk to try and provide returns. So there's a point at which capital requirements become too much. It is not that no matter how much capital, it's always a good.
Can you talk a little about how one advocates for regulation sort of on behalf of the banks, or given the environment where banks are so widely hated, where anything saying, we should not have such high capital requirements sort of carries this taint of working on
talking your book, yeah. I think there are, and it is, your premise is correct, it is difficult because of the environment, but I think there are several key aspects. One is that the industry has to work together. And the industry's view should be that, what it shouldn't be is if my competitor is hurt more than I am hurt, that it's a good. That's in fact a bad for the industry. So there's got to be more collaboration within the industry. I think a second aspect of working effectively is to be data-driven. A lot of these arguments exist without even the slightest bit of realistic, meaningful data. And so collecting the data is another piece of the argument. That is much more effective than rhetoric. And third, it is important not to be too shrill. I mean, the regulators almost in all parts are really trying to do the right thing. They can be wrong like anybody else, but to be shrill is not the way to advocate most effectively.
Does disintermediation of the banking industry or the financial services industry drive some of this? I mean, you talked about some of the firms that are trying to compete for banks. They have in many ways a lot of regulatory advantages because they kind of come from nothing and don't have the regulatory apparatus. And they probably want banks to be more heavily regulated and not to be able to compete with them. Is that a problem that you actually see in
I think your point is very well taken. I think one of the reasons for disintermediation is the regulatory distinction. I think I've always thought there was what I call the regulatory axiom to Gresham's law, which is bad or no regulation drives out good regulation. And we saw it during the mortgage crisis. This originated with a number of mortgage lenders who were either unregulated totally or, I think, say, superficially regulated. And that starts to spread throughout the entire financial services industry.
I'd like to turn to investigations where there's a sort of similar dynamic. I'd love to hear how you kind of negotiate in these adversarial situations where the ability to be adversarial is so limited, right? I mean, there's so much power in the government and a sort of demonstrated willingness to use it. What can be done for kind of banking clients who are caught in a LIBOR or FX or even mortgage scandal?
Again, the premise is correct. The leverage of the government is enormous, and there is relatively limited negotiation ability on the part of the bank. I think the most important aspects of this is when you do your own investigation, as I indicated, to be as thorough as possible, to try and cooperate to the greatest extent possible, to become, it would be a total exaggeration to be seen as a partner of the government, and that's not what the lawyer's role should be in any event, but at least to create within the government authorities a sense of trust that they can rely on your client and you to tell them the truth. And that's not going to end the investigation, but it can mitigate the penalty.
So that sort of builds some goodwill. But do you think that regulators kind of start from a premise of wanting exponentially higher fines? Do you think there's been overreach in some of these penalties, or is it all kind of deserved?
No, I don't think it is all deserved. I think there has been, in certain cases, overreach. These are, of course, judgment calls, but I would regard some of it as overreach, and I particularly worry that as now the regulators having seen, or law enforcement having seen, that banks can plead guilty to criminal offenses without sinking beneath the sea. This will attract or make it more attractive for the government to seek further criminal penalties, but there are potentially more collateral consequences to come, and at some point you reach the tipping point. So there's going to have to be a lot of judgment here by the Department of Justice as to how far they push.
Do you think that, what are the collateral consequences that haven't shaken out? Well,
let's take an example. And I'm going to go back in time. The two prominent banks that pled guilty to a criminal offense some years ago were Bankers Trust and Riggs. Bankers Trust at that point happened to be a New York State chartered bank. As a New York State chartered bank, if you plead guilty, you lose your ability to have any trust accounts. That's like fatal. The only way you can get around that, seriously, is to go to the pardon board in New York the same way a convicted heroin dealer would. That's not going to be a fun situation, and I would not encourage a client to believe that they would ever get the pardon. So if a major bank were deprived of its ability to offer trust services, that could be very detrimental. I think the SEC and the Department of Labor to date have been relatively constructive in the waivers they have given. Who knows what will happen in the future?
And speaking of that, do you think we're nearing the end of these sort of billion-dollar investigations, or is that kind of the new normal and we're going to keep seeing them?
I certainly hope it is not. We're going to see still the knock-on of some of the LIBOR and foreign exchange investigations. But knock on wood, I have not seen anything yet over the last few months which approaches those two plus sanctions. That is in part, I think, because the banks have really gotten the message and the compliance is so much better today. But inevitably, as we are sitting here, it will happen to at least one bank, something.
All right, well, thank you very much for your time. Thanks everyone for coming. I think the program will continue upstairs after lunch.